Hello. The appointment of keepers of the peace began in 1277. These Crown officials were allocated an area, most usually a shire county, to ensure offenders were brought before the courts. In 1361 they became JPs, Justices of the Peace, with the power to try cases. In the late medieval period, cases from the Sheriff's Turn were transferred to quarter sessions, presided over by JPs. At every level, maintaining law and order was a communal responsibility. Manorial lords or their representative presided over local courts, which convened twice a year, typically out of doors in the Middle Ages, and were attended by all the men of the manor over a certain age. There were two main types of manorial court: a private court baron, dealing with administrative affairs such as property transfers and enforcing customs and regulations within the manor, and a court of public jurisdiction, known as the court leet, that dealt with minor offences under common law, although some manorial lords had the privilege of infang thief, the authority to hang a thief caught within their manor, either in the act of stealing or in possession of stolen goods. A select few had more extensive rights of outfang thief, the authority to hang thieves taken outside their manorial jurisdiction. The court leet was also responsible for ensuring all eligible men were members of a tithing, typically a grouping of 10 men responsible under oath for bringing any member accused of an offence to face justice, which we mentioned in part 2, and making appointments to various official manorial positions. For example, an ale taster, to check the quality and measure of ale sold, a position that often also covered testing the quality and weight of bread, a kind of early trading standards inspector. By the mid-14th century, most towns had bylaws governing brewing and baking, and set times when market trading was permitted. Boroughs with markets held courts of pie poudre, or pie powder, from the French pied poudre, meaning dusty feet, on market days and fairs when visitors were expected in order to deal with offences on the spot. Other manorial positions to be filled were those of a pinder, to round up stray livestock and hold them in a pinfold, and a constable, to uphold the law and assist keepers of the peace. Those appointed usually served in the role for a year. The ale taster may have relished the perks that went with the task, but the positions were unpaid, and that of constable was particularly unpopular. It was the constable's job to issue warrants and to maintain a means of confinement and punishment. Stocks had been in use for centuries when a Statute of Labour's Act passed in 1405 made it compulsory for every town and village to have either stocks or a pillory. Stocks were hinged boards in which offenders could be clamped seated, generally by the ankles, sometimes by the arms as well. This set of stocks is at Chapel on the Frith in Derbyshire. In a pillory, more common in towns than rural villages, offenders were secured by their head and arms in a standing position. Public humiliation was part of the punishment. Stocks and pillories were usually sited in a public space, often a marketplace, handy for rotten veg and fruit to throw at those held, or a village green. This public shaming is the origin of the phrase a laughing stock. Stocks were used to hold people pending trial, but typically it was punishment for a minor offence, often what would be classed today as antisocial behaviour, and the penalty would be to be confined for a set period of time, say 4 hours. Sometimes the offence committed would be made public on an adjacent notice board. Common offences were drunkenness, blasphemy, playing sport on a Sunday, or for traders selling shoddy goods or short-changing customers. Vagrants were also subject to being put in the stocks before being sent on their way. Medieval communities lived, worked, worshipped and celebrated together. Strangers were viewed with fear and suspicion. It paid to belong in medieval England. Vagrants might also be whipped, but whipping, either at a whipping post, this example is at Stowe in Lindsey in Lincolnshire, or tied to the back of a cart and paraded while the punishment was administered, was generally reserved for women. The iron manacles on this otherwise innocuous-looking sandstone pillar in the tiny village of Great Gate in Staffordshire are a clue that it was originally used as a whipping post. Other inventive punishments for women in the past, although there is no evidence this particular penalty was introduced before the mid-16th century, include the scold's bridle, a metal cage fitted over the head to clamp the victim's jaws shut, perhaps a punishment for malicious gossiping. The cooking stool involved the humiliation of being put on public display tied to a chair. The ducking stool was a watery variant, where offenders were dunked in a pond or river. Imprisonment increasingly replaced stocks in the pillory in the post-medieval period. A secure lockup became a legal requirement of every parish from 1780, and stocks slowly disappeared. Interestingly, the 1405 Act that made their maintenance compulsory in every town and village has never been repealed. Many have survived, although in most cases they will have been heavily restored. Next time, a look at some of the dodges available to avoid paying the penalty for a crime. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.